Thank you for joining us. This is the opening session of our 2024 edition of Wills Week. So very excited to be kicking off another week working with a number of fantastic wills and estates lawyers here in Edmonton. Happy that you could join us for our opening session. I am going to be introducing our guest presenter here in a second. But before I do, just some quick housekeeping and some introductory notes before we get started. So thank you again for joining us today. My name is Matt Mandrusiak. I am the Manager of Philanthropy with Edmonton Community Foundation, and I am the host of your webinar this afternoon. Thanks to an amazing group of volunteer lawyers and tax professionals, this year's Wills Week offers 13 presentations, both in person and online, to inspire and guide you in the proper preparation of your estate plans. These plans include not only a will to protect your family, your business, and your assets, but also 2 additional documents to help you during your lifetime, should you temporarily or permanently lose your independence. Understanding the hardships and additional costs that will occur when these estate documents are not in place correctly will help you appreciate the value of getting professional help for you and your loved ones. Edmonton Community Foundation is pleased to provide Wills Week as an important resource for Alberta-based will and estates information. It unites our role as a trusted partner to help people create legacy for their community. Our area of expertise is endowment funds, contributions that are invested and provide ongoing support to enhance our community during and after our lifetimes. To learn how these funds are affordable options and how they can help save you taxes, please visit our website, www.ecfoundation.org. You can also find that website address in the Wills Week logo to my left or right, depending on how you're looking at the screen, I guess. In our work, we see a lot of wills and understand how powerful these documents can be. We want everyone to benefit from these Wills Week sessions and understand how professionals can make your will more effective and accurate. If you have any questions for Anna May during this presentation, I ask that you please use the Q&A box throughout the presentation. Anna May and I have talked before we started this session, and she's going to take questions towards the end of the presentation. So she's going to go through her slide deck, her information, and then take questions and answer questions at the end. By all means, if something comes up as she's speaking, please use that Q&A box. I do ask that for the sake of everybody on the webinar, that we try and keep questions somewhat generic. Specific questions may not be answered because there are likely answers that Anna May will not be able to provide, not knowing your specific situation. So if there are more generic questions, please feel free to add those into the chat box. I also need to advise you that, of course, we are recording this session so that this can be an ongoing resource for people like yourselves who may want to revisit this presentation or share it with folks who may get some interest in listening to this conversation. Our recorded sessions will be posted on our website within the next couple of weeks upon the completion of Wills Week. And finally, at the end of this webinar, I ask that you please just take a couple of minutes to answer the survey questions that we have in place. We want to make sure that these sessions continue to be a valuable resource for the people who are accessing them. And your feedback really does help us when it comes to planning Wills Week in the future. So please do take a couple of minutes to answer that survey. It will pop up when things end this afternoon. So now that you've heard enough speaking from me, I am going to introduce our presenter. We're very pleased to be joined by Anna May Choles, who will be leading this opening Wills Week presentation. And I'll give a quick bio before turning it over to Anna May to take over. Following an undergraduate degree in honors political science at the University of Alberta, Anna May earned an LLB in 2011 from the same institution. As a law student, Anna May gained critical legal research and analysis skills by working as a student researcher for the Center for Constitutional Studies and the Alberta Law Reform Institute. During this period, she complemented her studies by volunteering at Student Legal Services in the Civil and Family Division at the Edmonton Kids in the Court program and the Golden Key Honor Society as a mentor for English Key program. Since being called to the Alberta Bar in 2012, Anna May has gained comprehensive experience in advising clients in various legal areas, wills, estates, real estate, corporate commercial law. She continues to remain active in both her legal and broader communities and currently serves as co-chair for the Elder Law section for the Canadian Bar Association Alberta North, is a volunteer for Junior Achievement, and is a member of the Society of Trust and Estate Practitioners and has the designation of Trust and Estate Practitioner, TEP. She is also a regular presenter with us here at ECF during our Wills Week presentations, and we certainly appreciate the help and expertise that she provides on an ongoing basis. In her spare time, Anna May enjoys ultimate frisbee and hiking. So thank you very much, Anna May. I am going to turn it over to you. I'm going to turn off my camera, and I look forward to your presentation. So take it away.
Thank you very much, Matt. Good afternoon. My name is Anna May Choles. I am a partner at Rackland Company here in Edmonton, and I am going to be doing the presentation Wills 101 for Wills Week for the Edmonton Community Foundation. I'd like to start off by confirming that the information in this presentation is going to be legal information, not legal advice. So this is intended for information purposes. You need to seek out your own legal advice, talk to your own legal advisors or lawyers in order to get proper legal advice on your particular situation. This presentation provides legal information only. So what will we be discussing this afternoon? Well, we're going to cover a variety of topics relating to wills. First off, what is a will? We've got to start there. It's a building block of any discussion as to the importance of wills. We're going to review why you should make a will. What do we mean when we talk about your estate? Who or what is a personal representative? And who would care for your children in the event of your death? We're also going to talk about what you put into a will. So the way that you would distribute your estate or the types of gifts that you're going to give in your will, or that you could give in your will should you choose to. Tax concerns that would affect your estate, types of trusts for potentially children, for adults for whom you might want to leave money. And then I just have a few general wills questions at the end. So some questions I'm frequently asked to just sort of quickly go over there. Now, I always like to start off with some definitions. There's a lot of legal terms of art in estate law, and as much as we try to bring in plain language into the discussion, there's still some words that we have to use, the old Latin form or really specific terms, simply because that's what the legislation says. So the first term that we're going to refer to, that I just want to make sure that everyone's aware of what it actually refers to, is an adult interdependent partner. So adult interdependent partner is the Alberta specific term for common law. And it means people who have either lived together for 3 years, have lived together for less than 3 years, but have a child together, or have signed an independent partnership agreement with between the two of them. So those are the categories of people who are adult interdependent partners. And as you'll see in the presentation, they fall into a specific category of having specific rights in an estate situation. All right, so beneficiary. When we refer to beneficiary, we mean the person who inherits or receives a gift under the will or under any sort of other testamentary document. Estate. We're going to get into the specifics of what can be considered part of your estate or fall outside of your estate a little bit later on in the presentation. But to start off with, when we refer to estate, we're referring to all of the assets of the deceased person that are distributed under the will. Personal representative. So personal representative is the word that we currently use in the Alberta legislation, and it's the person who's in charge of the estate. They're in charge of dealing with all the assets, distributing the estate. They would get any court orders. Sometimes they're also referred to as an executor or an administrator. Personal representative is sort of the broader term that covers both executors and administrators. Probate. One of the questions I get asked most frequently when I'm meeting clients to talk about estate planning is, what is probate? What do we mean when we say probate? And quite simply, Probate is the process by which you prove a will to be valid in the courts, and then once you prove that will to be valid, you obtain what's called a grant of probate. So yes, this is the official will, and we've certified that with a grant of probate from the court. Not every estate requires a grant of probate, and we can get into a little bit of what types of estate may not, but really that's very fact specific and it depends on your circumstances. So that's really an area where you should be getting specific legal advice. Intestate. Intestate is a word that we use to refer to someone who does not have a will when they die. So if they die without a will, they are intestate. Therefore, testate means a person who died with a will. And then the person who drafted a will is called the testator. These words are a little bit archaic and a little bit of the old school Latin, but these are still the words that are technically used in the circumstances. So it's important we know what they mean specifically in an estate context. And then lastly, a trustee. So a trustee is the person who administers any of the trusts set up under the will or would administer any sort of a trust. All right, so now that we've got our definitions started off with, let's start off at the very basics. What is a will? Well, a will is a document that sets out who's going to be in charge of your estate and how you want your assets distributed or dealt with in the event of your death. There's two main aspects to a will, although it can do other things as well. But number one, we always want to see the appointment of a personal representative or an executor say, okay, when I die, here's who's in charge. And then number two, you're going to distribute your assets. You're going to say, here's what happens with my stuff. Here's who gets my stuff. And that could be money, and that could be personal, or that can be personal property. It really depends on the circumstances. And by personal property, I mean things like household goods, personal effects, things of that nature, or even it could be real property as well. So before we can get into wills and what we do with them, we should cover what a will does not do and cannot do. So a will in legal terms is of no force and effect until you've died. So the person you've named as your executor under the will has no authority to act on your behalf while you are still alive. So this means if you lose the ability to make decisions at any point during your lifetime, whether that is because you end up in a coma, if you suffer a head injury, as I've seen some people lose capacity because of over-medication, or if you get dementia or Alzheimer's or something like that, where you ultimately lose the ability to make decisions, the will doesn't cover that time period. It's helpful once you've passed on, it identifies what happens then, but it's not the only document you need. For a well-created estate plan, you need to have an enduring power of attorney and a personal directive as well. So the enduring power of attorney appoints someone to make financial and property decisions for you when you're incapacitated. Or that can be a document that starts before your incapacitation, continues past it, depending on the circumstances if it's an immediate document. And then the personal directive is a document that you sign where you appoint someone to be your agent. And that person you're authorizing when you can't make your own decisions to make your health care and non-financial decisions that do not relate to your state. So all of your personal decisions. So things like what sort of health care you should get, whether you should get surgery, at what point do you stop having certain types of active care? Would you want to be admitted to an ICU unit? It also covers things like deciding what sort of care facility you should go into and when you should go into a care facility. So those are both very important documents, but they're just not covered in a will. You should also never attempt to incorporate them into your will. They need to be separate, standalone documents. The will is one document, then the enduring power of attorney is a second one, and the personal directive is a third. They cannot be combined into one document. That would make them non-functional. So it's really important that you have all three documents. However, the purpose of this presentation is to talk about wills. So why make a will? What's the benefit of making a will? You're dead. What does it matter? Well, it gives you the power to determine what can happen after you die. So it allows you the ability to say who gets money from your estate and who gets assets. It also allows you to identify who's control and administer your estate. So who's going to be the person who manage everything once you've passed on. If you have any minor children or minor children for whom you are the legal guardian of, it may allow you to name alternate guardians to say, well, who would take care of your children in the event you were unavailable to do so, or in the event you were deceased and could not take care of them and their other parent could not take care of them. It also allows you to set up a scheme to ensure that any minor children are properly taken care of, or any disabled children who you might want to have support throughout their life. It allows you to set up things like trusts, which will ensure that, through which you can ensure that nobody inherits assets before they're ready. So you can think about, say, well, actually, if I die and this person's still young, can I delay them getting the money till they're a bit older so that they've had a chance to mature and make better financial decisions? If you have a business or a farm, it can be very important for succession planning, for how you're going to set up how your business is going to either continue or not continue, depending on the circumstances. It also can allow you to do some tax planning to say, well, it allows you to sit down with a lawyer and perhaps an accountant to sit down and say, okay, well, what are the assets I have that have certain tax liabilities? How can I deal with those in a way to either minimize or make sure that there's enough assets in my estate to pay the tax on those assets? It allows you to give gifts to charities. That can be an important part of tax planning to say, well, I know I'm going to have a bunch of tax on my death, and we'll talk about that a bit later, but gifts to charities can be an important part of dealing with that tax liability because you're getting charitable tax receipts. And it also can allow you to simplify your administration. Fundamentally, one of the things the will does is it creates a clear document to say, here's who I appoint and here's what I want to have happen. And that makes things so much easier in the event of your death because it really takes away a lot of the confusion and the difficulty, and it makes it a nice, simpler process for your family to deal with, which is very important, that they have everything simplified as much as possible because they will be grieving, so it will already be an extremely difficult time for them. So before we get into all of the aspects of making a will, let's talk about what happens if you don't make a will. Like I said before, if you die without a will, you are said to have died intestate. In that case, the Wills and Succession Act of Alberta tells us what happens in the event that you die without a will. So first off, I said there are two major parts. It's of your will, who's going to be your personal representative and who's going to inherit your assets. You don't have control over either. You don't get to say who the personal representative of your estate is. There's legislation, and that's going to be also in the Estate Administration Act that says, okay, if you don't have a will, we're going to make certain assumptions about who your executor or who your personal representative should be in that circumstance. Sometimes that means it's a person who really isn't ideally suited for that. It can also make it more difficult to deal with banks and other institutions because they like to see a will and a death certificate when someone dies. And that way they know, okay, the person has died, and okay, this will said this is who's in charge. Now I know I'm dealing with the right person. When you don't have that will to say, I am the person entitled to this information, it makes it a lot harder. They don't necessarily want to give you the information. You might have to take additional steps. You might have to get the lawyer to write letters to say, well, actually, I'm telling you we need this information because you need to get the information as to what the assets are before you can even apply for any grants from the court. So it makes it a lot easier to have the will there because then everyone knows who's in charge and that they're dealing with the right person. Also, we have legislation that governs what happens when you die intestate. So there are certain assumptions made that, everything should go to your spouse if all of your children are of the relationship from your current spouse or adult interdependent partner. If they have children from a prior relationship, then the assumption is, well, either the first $150,000 or the first 50%, whichever is greater, goes to the spouse or adult interdependent partner, and the rest gets split equally between the children. That may not be the actual intention. And so it can be quite complicated. Also, the wills and succession legislation doesn't make allowances for stepchildren. Stepchildren can be really situationally specific. There are some stepchildren who are absolutely full and complete parts of a family. And there are some stepchildren who, because of various different situations, have their own family and are not really well integrated into yours. And the legislation assumes that, well, no, they don't have any right to inherit. So stepchildren don't have any automatic right to inherit under intestate succession. So if you wanted to make sure they were inherited, you'd have to have a will to do that. You also means you can't give gifts to other sort of non-close family members, things like charities, friends, everything like that. There'd be no assumption that they would have any rights in that situation. If anyone who is a minor, so as a person under the age of 18 is inheriting, then their share in the estate would automatically be held in trust by the public trustee's office until they were 18. And then they get the whole trust, that whole lump sum of money at 18, which may not be what you want. It also doesn't allow you any opportunity for tax planning or thinking about the tax impacts of your assets. You may have family members who inherit. So in a situation where, say, you didn't have a spouse or adult interdependent partner and you didn't have any children or grandchildren, and maybe your parents aren't alive, so now we're going to brothers and sisters and potentially nieces and nephews. Well, maybe that you really don't like your brother, and the last thing you'd ever want was for him to inherit from you. But if you didn't do a will and there's nobody else who can inherit, then he's going to get it. And so you really want to make sure that you're choosing the people you want to have inherit, and you're making sure that the people that you simply do not intend to benefit don't inherit anything. Ultimately, at the end of the day, if there are no known heirs that can be found, the money can end up going to the government, but that's really not a first case scenario. That's only once there's no one else around who has the right to claim the money. All right, so how do you make a will? Well, broadly, what a will needs to do is be in writing and be signed by the person giving the will, who is the testator. There are two main types of wills in Alberta. The first one is what's called a holographic will. So that is a will entirely in your own hand, and then you sign it, and ideally date it as well. And when I say entirely in your own hand, I mean you took a pen and paper and wrote it out. You cannot type it and then sign it. That's not a holographic will. That's a formal will. And that's the second type of will. So a will that is in any other hand other than the testator's. So it can be a typed document, someone else could have written it out, but then it needs to be witnessed by two witnesses. Now, you also have to be cautious about who your witnesses are, because if you have a beneficiary under the will, witness it, your will, or the spouse of a beneficiary under your will, witness the will, then that gift in the will is automatically deemed to be revoked, and that gift is no longer valid. So that's one of the many reasons that going to see a lawyer makes good sense, is because then you can ensure that your beneficiaries, that the people who are witnessing your will would typically be a lawyer like myself and maybe another lawyer or a legal assistant at our firm, are the people witnessing the will, and you're not accidentally revoking any gifts with your witnesses. Unless you desperately wanted to leave money to your lawyer, in which case I'm sure they could find a different witness for you. So when we refer to your estate, what do we mean? So we're saying that the will deals with the assets in your estate. Well, your estate is typically owned of all the assets owned solely in your own name at the date of your death, and and any assets that don't have named beneficiaries. Then these assets are distributed according to the terms of your will, or if you die without a will, according to the terms of intestate succession. So that seems nice and simple, but actually, as we're going to go through it, it gets a little bit more complicated, because that's fine at the broadest level. Oh, it's all the assets in solely your own name. But what do we really mean by that? So what this means is that what would be included in your estate is assets where you're on the title alone, or where you're on the title as what's called tenants in common. So that can include any real property, any mines and mineral rights, any bank accounts that are in just your name, shares in companies, investment accounts, any vehicles, all of your personal goods and household effects, things like that. So all of that forms part of your will. Now, what typically falls outside of the estate, depending on the circumstances, would be jointly owned property. For example, a home if jointly owned with your spouse. Now, when we say joint, we mean specifically you have to own that property as joint tenants with your spouse. If you're just both named on the piece of property and it doesn't say as joint tenants, so if the title just says Bob Smith and Sally Smith of 123 Street, Edmonton, Alberta, and it doesn't say at the bottom as joint tenants, you are not assumed to own the property jointly or as in joint tenancy for the purposes of the estate. And what happens is each half of the property is deemed to fall into your own estates. One of the reasons that that is a factor is that if you have property, if you have real property, so land that's owned in your name, even if it's a half interest or a smaller interest in property, you're going to need a grant of probate to deal with that. Or grant of administration, because the courts or because land house requires you to have a court order in order to deal with that land if the person who owns the property can't sign. Also, joint accounts. So typically between a husband and wife, or between a wife and a wife, or a husband and a husband, or between two partners in an adult interdependent partnership, there may be some joint accounts. And the assumption on that is typically that all of the assets go over to the survivor. However, it's not true in every single circumstance. So we'll go over that a little bit next. Then assets that have named beneficiaries also typically fall outside of your estate. So what can you name put named beneficiaries on? So things like your RSP, RIFs, LIFs, your tax-free savings account, insurance policies, pensions, all of those have the possibility of having a named beneficiary on them. Now, if they don't have a named beneficiary, then they in fact fall into the estate and are included by the assets that are going to be governed by your will. So we talked a little bit about jointly owned properties. We're going to get a bit more into jointly owned property. So we talked about the land. It has to be held as joint tenants. Otherwise, you're not going to have the same rights of ownership. But joint accounts. So the one thing to flag with joint accounts here is the rules are different if it's an account which has named on it an adult, a parent, and their adult child. So if you have a parent and an adult child, then there is a rebuttable presumption that it's not included, that is an estate asset. So if you have joint accounts with your adult children for any reason, you want to make it clear. You want to make sure you're getting the proper documentation to say, yes, this asset is part of the estate, or no, it isn't. Sometimes people put their adult children on their accounts to help them with managing their finances, to say, okay, well, maybe it's hard for them to get to the bank, or maybe it's kind of a pain to deal with internet banking or online banking. And someone along the line said, oh, if you put your children on your account with you, then they can help you. That's true. But then sometimes people assume that the money in that joint account is then the surviving child on that parent's death. Now, that's not correct in law, as there'd have to be a investigation review to say, well, what was intended here? Why were they on this account? Were they just on that account to help mom or dad manage the money, or was this intended as a gift to that child? And so not having that clarified with proper documentation, ideally from a lawyer to sort of say what the intention was, could lead to the possibility of litigation for your estate, and that's very costly. Ideally, if you're going to do any of these things, you want to go and see a lawyer so that the lawyer can do the documentation to say, either A, yes, this is absolutely intended as a gift to my child. I want them to inherit that full account once I've passed. This is my full intention. And then we document that so it's nice and clear. Or to say, well, no, I'm just putting my child on my account so they can help me pay my bills. They don't get this money. This is supposed to fall into my estate and be managed with the rest of my estate. But you want that to be as clear as possible, because there's a lot of complexity in this area. And you want to make sure that you're limiting the opportunities for litigation as much as possible by being as clear as possible. So, pensions, RSPs, RIFs, insurance policies. Typically, you have named beneficiaries on those, and then on the event, in the death of the person, that asset is cashed in and the total amount is paid to the beneficiary. So then that falls outside of the estate. Now, if the beneficiary named on the account has predeceased you, then they obviously cannot inherit. And either you've got an alternate named beneficiary on the asset, when some people do, or if there's no named alternate, the default beneficiary is your estate, and then it would be governed by the terms of your will. Okay. So one of the big things that we're going to do in a will when you're drafting it is determine who your personal representative is. So what is a personal representative and what do they do? This is the person that you're going to name in your will who is going to administer your estate. At the broadest possible level, that means that they're responsible for collecting, protecting, and distributing all of the assets in your estate. They also may be responsible to administer any trusts in your will. This is the person that's also called an executor, executrix. It's a little bit more of old school language, but you still hear it used quite a bit. Or in the event of an intestacy, so if you die without a will, then the person named is called an administrator or administratrix. And they still have all the same responsibilities of that personal representative, whether it's named in a will or not. So when you're thinking about who should be your personal representative, what are the things you should think about? Well, I want to let you know, you don't have to choose a lawyer or an accountant or someone with specialized knowledge of estates. Lots of people without a specialized estate background can be a very good personal representative or executor, especially if they're very organized, because there's a lot of paperwork, there's a lot of work, there's a lot of correspondence and following up. It really helps if they're very organized. Often people will appoint a spouse or partner or an adult child, sometimes a sibling, a friend, but it really depends on your personal circumstances. There are circumstances in which it makes sense to appoint a trust company. And each of the major banks has a trust company attached to them. I believe all of them have a trust company they can refer you to. And that's, you're hiring this trust company to be the executor to manage your estate on your behalf once you've passed on, to distribute the assets, deal with all of that. Now, of course, you're going to have to pay them. The estate will be responsible for paying their fees. But sometimes that makes sense. If your estate is complicated, if maybe you don't have any friends or family who lives close enough by, or you just don't want to bother them with it, or if you're concerned that there's going to be a high level of conflict. The most important thing you need to do when picking an executor is pick someone who is going to be trustworthy and willing and has the time to act. Sometimes picking, your friend who's a lawyer may not be a good idea. Lawyers are very busy and they don't always manage their time well. So you want to make sure that you're picking someone who's actually got the capacity to do this work for you. And so you really want to focus on people who have got the ability to do it, are trustworthy and are organized, and that's the sort of person who will make a good executor. So what are the actual responsibilities that you would be asking this person to do? So I said we broke it down into sort of 3 areas: collecting, protecting, and then distributing the assets of the estate. But what does this really mean? Well, first off, the executor has to determine what the assets of the estate are. That means they've got to go through all your records. They've got to try and identify all your bank accounts, all your investment accounts, life insurance policies, pensions, investments, where you owned property, anything like that. And so that's a lot of work just to begin with. They've got to first figure out where the assets in the estate are. Then they often have to get a grant of probate. Not always, but they'd often have to get some sort of a grant. And then they've got to go through the process of putting those assets into the estate's name. So that's often called a transmission, to transfer the assets, to say, well, now this person is deceased. This is who's in charge, the executor, and we're going to put these assets into the estate's name. They also have the ongoing responsibility for control of the assets and protection of the assets. So, for example, if you own a house at the date of your death, your executor is going to be responsible, or your personal representative is going to be responsible for making sure there is insurance on the house, making sure the taxes are paid, making sure that someone's checking on the house regularly within the time periods as required by your insurance to keep that insurance valid. Also, is someone mowing the lawn? Is someone shoveling the walk if it's the winter? Is someone taking care of that house and making sure it's still in good condition? They also have the responsibility of dealing with any claims or issues regarding your estate. So, for example, if you die in a car accident, there could be some insurance claims. There could be fatal accidents that claim. There are also maybe people who pop out of the woodwork and claim that you owed them money. Your executor is responsible for dealing with all of these claims and for determining which ones are valid and through working through all of the court processes for all of this stuff. So it can be quite a lot of work. So that's collecting and protecting the assets. The other part of the executor's responsibility is to distribute the assets. So what does that mean? Well, first off, it means paying all the debts of the estate. It means making sure the taxes are filed and on time and getting the taxes paid promptly. It's about determining what assets need to go to whom, making sure you can identify the assets that are described in the will, seeing if the person still owns them. It also means carrying out any instructions for distribution in the will. Sometimes people put instructions in their wills that is more than just, I give this to this person. We might have, an option to purchase in a will to say, well, I would like to offer to this family member the option to purchase this property for, whatever price or whatever discount, before it goes onto the open market. And if they don't proceed with it, okay, but the executor or the personal representative is responsible for managing all of that. They also will have a duty to ultimately account to beneficiaries, particularly residuary beneficiaries, at the end of the day. So they've got control over all of the assets of the estate. That means they have to tell the people who ultimately get that money, okay, well, here's how much money I had at the beginning. Here's the bills I paid. Here's the additional money I found. Here's how I distributed it at the end of the day. They've got to show that to say, well, what I did was reasonable and I spent this money correctly. They also have a responsibility potentially to administer any trusts. Now, you can sometimes in a will name alternate trustees to manage trusts, but often the default trustee is the executor of under the will or the personal representative. Sometimes we run into situations where a personal representative either cannot act or has decided that they won't act in your estate. So they might predecease you, so then they can't act. Maybe they've lost capacity by the time you die, so then they can't act. Sometimes they resign and say, I can't do this. Sometimes they've left the province or they've left the country, and so then actually having them resigning is the best option. But what happens? Well, part of this is drafting the will properly. And this is, again, why speaking to a lawyer is important, because typically most lawyers would say, well, we need at least one backup in your will. We need one backup to say, okay, if your first person can't do it or predeceases you, who's the number two? Sometimes we'll even have 3 or 4 people named, just as an alternate, okay, who then, who then, who then. Ultimately, if there aren't any more alternatives named in the will and all the people either cannot or will not act as executor or personal representative, then it goes based on the priority as set out in the Estate Administration Act to say, okay, who under the legislation do we assume should be doing this? All right, so that's all the matters relating to the personal representative. Let's move on to talking about children. So in the event you have minor children, so children under the age of 18 at the date of your death, you should be naming in your will a guardian who would take care of those children. Now, again, like before, often name one, maybe a backup guardian. It's a little bit different than an executor in that the court always retains the ultimate authority to make decisions about who the guardian of any minor child is, but they do give great deference to the wishes of the parents regarding the guardianship of their children. There could be a circumstance in which the person you've named as your guardian has, since the date you wrote the will, and between the date you wrote the will and the date of your death, become inappropriate to be the guardian for any number of reasons, and the court will take that into consideration when they're appointing a guardian. But it is very helpful to have that named in there, especially if you have multiple different family members who would be interested or want to take your children, so that you've set down what yourself and your other child's parent intend and want to have and who they should be raising their children in the event they cannot do it themselves. So what happens if you don't name a guardian in your will? Well, potentially we could have some more litigation and a fight. You might have various family members making applications to the court, various different sides of the family taking sides, saying, oh, here's who should do it, this is who should do it. But ultimately, if there's no and friends, if the person you'd really like to have raise your child is a friend of yours, they don't have good standing to bring a claim to be a guardian as compared to family members. So if the person you'd want to have raise your children, if you weren't there, is a friend, then you really want to make sure you've got that written into your will to give them the strongest possible position to say, well, I have the right to take care of these children. Ultimately, if we've got no family members who will step forward, Alberta Social Services will likely get involved with the care of the children, and that is really just a less than ideal situation. All right, so the next item that we'll deal with in the will is, well, how do you distribute the estate? This is often the meat of your will. We finished doing all the appointments. Now we're going to say, what do you want to have happen with the assets in your estate? So you can give gifts to friends, you can give it to family or charity, but you also have to think about, in naming who you want the assets in your estate to go to, is who is the people that would have claim on your estate under the Wills and Succession Act, as there are certain people who would. There are certain family members who would. Say, who do you have a legal responsibility to ensure that you're providing enough care for? So, who has a potential claim on your estate? So first off, the person you have a legal responsibility to is your spouse or adult interdependent partner. Now, when adult interdependent partner, I again mean that specific definition we referred to on, I think, the second or third slide, which was, okay, a person I've been living with for either over 3 years or less than that and have a child together or have signed an adult interdependent partnership agreement with. If they don't meet one of those criteria, just because they are living together doesn't mean that they have all of, just because the deceased was living with that person doesn't mean they have all of the rights of a personal of an adult interdependent partner. Also, you should be aware that it is possible to have both a spouse and an adult interdependent partner. If, for example, someone was going through divorce proceedings and the divorce had not yet been completed, but it had been several years and they've had time to be in a new relationship with someone for 3 years, and they pass on before their divorce is completed and all those matrimonial property issues are settled while they're still in the relationship with the adult interdependent partner. You also have a legal responsibility to your minor children. So children under the age of 18 years of age, they have a right to be properly cared for from the funds in your estate. As well, children who are between the ages of 18 and 22 years and are enrolled as full-time students. So part-time students doesn't apply, or working doesn't apply, working students don't apply, sorry, not working students, but people who are working but are not students, they don't have these same rights. But if it's between 18 and 22 years and attending post-secondary on a full-time basis, then they would have a right to claim to say, well, I have a right to be supported by my deceased parents' estate. Also, any adult children who are unable to earn a livelihood by reason of mental or physical disability. So these are all the people who would potentially have a claim against your estate to say, well, actually, what this says in the will isn't fair to me. I should get a greater share of the estate. And so these are things you need to think about in drafting your will. Am I making sure that if I have any of these people in my life, I'm leaving enough for their care. I'm taking proper care of them. I mean, making sure that my legal responsibilities to them are being met through the terms of my will. So what are the types of gifts that we give in a will? Well, roughly we break the specific gifts out into 2 categories: specific gifts and residual gifts. So specific gifts can be a lot of different things. It can be gifts of personal property. So things like I give my car to this person, or I give my china teacups to my nephew Ryan. It can be gifts of specific amounts of money. I want to leave $5,000 to each of my grandchildren alive at my death. You could specifically give assets like land as say, okay, well, I own this, lot out near Lac St. Anne, and I want to give that to my sister, Rebecca. You can do all of those things as specific gifts. Then we also have the gift of residue. So that is, once we've paid the taxes, once we've paid all the debts, once we've made sure that everybody is settled out, and we've given all of the specific gifts away, how much money is left in the estate? Or what assets are left in the estate? Then the people who get the gift of the residue, they get their share of that asset. So it's whatever's left once we've paid all the debts, we've filed and paid the taxes, everybody's paid out, we've given all the specific gifts away, how do we share what's left? So when we're distributing a will, and you have to think about this because this is typically how we draft a will, what are the priorities for distribution? Well, the first priority is debts. We have to pay the debts first. Funeral and testamentary and estate expenses, those have priority. So funeral bills need to be paid right away. Taxes also have a priority, not over funeral bills, but they do have a priority. And then we've got legally enforceable debts, including claims against the estate. So legally enforceable debts are going to be things like, if you've got a line of credit from the bank, if you've got credit card bills. It can also be debts to individuals. Now, if you don't have good documentation as to what debts have been paid or not, or what debts are remaining, then your personal representative or your executor has to spend the time going through and trying to assess to say, well, does this person have the backup and the information to prove that I did in fact borrow this money from them? Ideally, typically there's some sort of documentation like a promissory note to sort of say, yes, this is what was going on here and what was the repayment schedule and what has or hasn't been repaid. But that can be something that an executor has to deal with. And then once we've paid all of the debts and the taxes and all of that, then all of the specific gifts in the will get given. So, anything that you're given from your household, any gifts of specific amounts of money, any gifts of specific items like vehicles or pieces of land that are intended to be specifically given. And then after that, we say, okay, everything that's left, that goes into the residue, and we divide that up as follows. It is very important to do that residuary gift because it's often very difficult to establish to ensure that you're giving away absolutely everything in your will. And also, if you don't include a gift of the residue in your will, then your will is deemed to be a partial intestacy. So that means even if there's no real assets to go to anyone at the end of the day, we still have to give notice to the people who'd be entitled to receive a share of the estate under intestacy, which can cause all sorts of issues. So we give away the residue. Okay. But we need to think about things like here. We talked before, what if your executor can't act, or what if they've predeceased you? We're not worried so much about beneficiaries not acting, but what if your beneficiaries have predeceased you? You said you wanted your car to go to your son Bob, but if he's not there, should it go to your grandson? Does that gift fall into the residue? What's your expectation? And one of the reasons that you sit down with a lawyer to discuss your will is so that they can talk you through all those alternatives to say, okay, well, what about this? What happens then? What happens here? So you often see wills drafted by lawyers that have alternative beneficiaries. Okay, if my children aren't there, then their share would go down to their children. Is a common clause, but that doesn't match everybody's scenario. We also will often sometimes put in something called a family disaster or a total disaster clause. What happens if something happens to you, your spouse or partner, your children, any potential grandchildren? If all of the people you thought you were going to give your money to disappear, what do you do then? Well, you want to have a family disaster clause, because otherwise then your will would be subject to the terms of intestate succession. This is where often people, if they haven't already done so in specific gifts, think about gifts to charity. Say, well, if my family's not there, here's my charity, or here's my friends. Now, you can also give money to charities and friends through specific gifts or residuary gifts if that's your choice. But it's always an opportunity to have that consideration again. Well, if I don't have any kids and I don't have any grandkids, maybe that's the best option for me. Hopefully it never happens. Hopefully it never comes to that. But it's always good to have those clauses in there so that we've got the full variety of options covered just in case. So going through the gifts of personal properties. So typically that gifts of household goods and personal property. And the reason we want to have something deal with that specifically in the will is sometimes those things are hard to divide up. Money can be easier. If you die with $300,000 and you have 3 kids and your will says to my 3 kids equally, great, everyone gets $100,000. Nice and clean. However, if you have family heirlooms, jewelry, artwork, antique furniture, items of other specific value, it can be a lot harder to divide them up. There's often only one. Coming up with a rotation where it gets shared back and forth between various different siblings isn't usually a workable plan. Cutting up the heirloom isn't going to work. So you need to set out in your will, well, who should this go to? And if they're not there, who should be the backup? If you have firearms, you really want to think about how you're going to deal with the firearms as well. If your executor doesn't have a firearms license, it can be a problem for them to hold on to the firearms for any length of time. So and if you're going to give the firearms to anyone, you should really make sure that whomever you're giving the firearms to also already has a firearms license. So minor children are not typically a good idea to give firearms to because they do not have licenses. So maybe you should pick someone else in the family who you can give that asset to, who can, or they could hold it in trust for the minor child or something like that. It's very important that that asset go to them. You can create plans here about, okay, well, letting all of my children or my friends pick through the house. You just want to be careful not to make this plan too complicated or arduous or expensive to take place. Household goods it's very expensive to fill up a household and to get all the things you need to do to run a household, but there's not really much of a resale market for them. So you want your family members and friends to be able to take the things that are of emotional value to them, but you don't want a complicated situation where you've created this very complicated, rotary of picking names and then organization of who can go in and what and get what. You want a nice simple system that says, okay, I've identified the key things. If other people want things, here's how this process will work. And other than that, my executor can deal with the rest. All right, so the next item I want to talk about is taxes. Taxes on your death are a bit more complicated than your regular tax filings that you do every year. That is because you are deemed to have sold almost all of your assets immediately prior to your death. So any capital gains that you had on assets that have accrued but not been paid, those would need to be paid on your death. Different other assets would need to be paid. You still have your regular income tax for that year. So it can be a lot bigger number. And it's important that you think about and have that conversation with your lawyer about it, because that's going to change how much money you actually have to distribute at the end of the day. It may not be what you think it is, depending on what the tax amounts are. So when we're talking about taxes, we're talking about, like I said, capital gains. All of your property, investments, all those capital gains need to be paid. Any shares that you own at the date of your death. If you own a property beyond your principal residence, that will have capital gains. The capital gains inclusion rate just changed in June of this past year. So it is now higher than it was before. And that will increase the amount of money that you have to pay on your passing. The other thing you need to think about is income tax on assets like RSPs, RIFs. Oh, that says LITs, that should say LIFs. So life investment funds and pensions. So those assets were, because they were a tax deduction coming in or in a retirement savings vehicle, then they are often fully taxed as income in the year of your death, and they could result in a significantly higher tax bill than you were anticipating. We can also sometimes run into a complexity where like I said before, if you've named beneficiaries on those assets, and that beneficiary receives the assets, but it's actually your estate that's responsible for paying the tax. So you want to make sure that you're thinking through, well, is there enough money in my estate to pay the tax on that asset if it goes to this beneficiary instead? Things like that. There are some exemptions to your taxes that you can think about. Principal residence exemption. So you do have a capital gains exemption over your own principal residence. That's a massively important exemption. Small business exemptions. There can be certain circumstances under which certain types of shares that you can own may be exempt from capital gains up to a certain amount in certain circumstances, but it's a very fact-specific situation. It's not, you can't just estimate it. You really have to make sure that the company is meeting the exact specific terms of what we mean by that. So you really want to work with an accountant there. Agricultural exemptions, if there's a history of agricultural use of the land in your family or fisheries, then not just agricultural land, but also fishing land, then typically that would also have access potentially to an exemption as well. And so it's very important that you get proper accounting advice. And it's very important that you speak to an accountant regarding filing of these taxes to make sure that we're taking advantage of all of the credits available, all the exemptions available, but also getting the proper advice to say, well, what do I need to be declaring so that you're paying that correct amount of money upfront? This is meant to be sort of a rough review of the taxes. Tomorrow evening, Michelle Coleman from MNP will be doing a presentation. I believe it's starting at 6:30. I believe it's also an online presentation going more into the details of taxes paid on death and how that works. So if you have any questions about that, please feel free to attend that presentation and ask Michelle your questions. I know just sort of the outline of these are the things to be concerned about. Michelle can get you more into the details on those. So you also have to think about the tax filings that your estate is going to have to do. So first off, your personal representative or your executor has to file a terminal T1 return. So it's due typically when a T1 return is due. So April 30th of the year following the date of your death. And that's the taxes from January 1st of the year you die till the date of your death in that year. If you die in the last couple of months of the year, you can get a bit of an extension, and then it's 6 months after your date of death. But really, it's not pushing it past about June 30th or July 1st. That's when all of that, at minimum, the taxes would be due. And so you need to have them filed and paid by that point. A personal representative will also have a need to file taxes on an ongoing basis. So I said that that one tax return took you from January 1st to the date of your death, but any increase in value in any of your assets that occurred after the date of your death, so if funds were invested, if there were changes in share values, if there was interest, there are GICs that matured, that all gets dealt with in a separate tax filing called a T3 return, and your estate has to do one of those for each year that your estate remains open. All right, so another item that we deal with primarily, often in wills, is trusts. So a trust is established when you provide your assets to one person who's going to be the trustee to hold it for the benefit of a third person who's going to be the beneficiary of the trust. So broadly, there are two types of trusts. Testamentary trusts are wills set up covering after your death. So often they're trusts set up in wills, things like that. You can also do trusts set up while you're alive. That's called an inter vivos trust. Because we're talking about wills, we're going to talk primarily about testamentary trusts in this presentation. All right, so trusts in wills. Well, the first thing to know is that actually your whole will is a trust document. You were giving your assets that you own at the date of your death to your personal representative or your executor on the trust that they're going to follow the terms of the will. That is in itself a trust. However, we often seek to set up other types of specific trusts in your will. What if you have someone who's under the age of 18 who inherits? What if you have adults who either shouldn't inherit their money right away, or we want to put it under certain controls for the rest of their life, depending on for certain specific reasons? Well, in that case, we can set up trusts. So for example, for children, children cannot receive money directly until they're at least 18 years of age. If you don't set up a trust in your will and you have a person under the age of 18 who inherits, well, then their share is going to be held in trust by the public trustee's office until they've attained the age of 18 years, and then they'll get their money then. So if you don't want that, if you want them to not get all of their money at age 18 for whatever reason, then you want to set up a trust in your will that says, okay, well, maybe I'm going to wait until they're 21 or 25 or 30. And then you can also name the person who's going to be the trustee in your will. You can say, okay, well, this person's trust is going to be managed by, my grandchildren's trust is going to be managed by my son, because he's the person who's best able to do it. Also, when we have bigger trusts, so particularly if you were leaving money to your own minor children, sometimes we talk about doing what's called a staggered trust. So we can say, well, we don't have to give all of the money to the children at one time. We could set up a situation where we give them a little bit of money at one age and a little bit more money at another age, and then the rest at a third age. And you can set up what percentages. So it could be, a quarter, a half, the rest. Could be different numbers. We could do more than 3 distributions. There's lots of different options. So you can do a number of different things with that. That is, again, where it's important to have proper legal advice so they can sit down with you, talk to you about what this looks like, make sure the document is properly drafted and correctly reflects your intentions regarding any trust for your children. Also, another important aspect of having a will properly drafted is ensuring that your trustee has the power of encroachment. So that gives the trustee the power to release money early for the health, education, and welfare of the minor child. So it may be necessary to say, well, during the child's lifetime, they might need money before they turn 18 or before they turn 21 to make sure that they're getting proper education, or to pay for braces, or to pay for whatever their needs are. And you want to set that up so the trustee's got the power to say, yes, I think that's a reasonable expense. Let's give them the money for that, or no, it isn't. Ultimately, your trustee, whoever you name to manage that trust for the minor child, is accountable to the beneficiary for their use of the trust fund. So they have to account just like the personal representative does to say, okay, I got this amount of money. Here's what I spent. Here's what was invested and here's the money it meant. Here's the money we had left over at the end of the day, so that the beneficiary can see exactly what they've done with what is frankly, the beneficiary's money. So we also often might want to set up a trust for an adult. So sometimes we have a situation where maybe we want people to just not inherit till they're just a bit older, and we're going to do a different staggered ages than before. We want to wait till they're kind of 30, 35, 40. Or sometimes people will say, well, actually, I want my kids to receive the money, but based off of how long it has been since the date of my death. So, 10 years after the date of my death, They can get some money, initially, and then I want to give them the rest 10 years later or something like that, whatever it is that works specifically for you and your family. Now, we also have other trusts that are dealt with for adults, and we often call those discretionary trusts or Henson trusts, or what they're called in other provinces. So it's a very similar sort of trust. And the idea behind this is the type of trust we would use for someone who is disabled and is receiving government assistance. So, especially in Alberta, the way that AISH works is that you can only have a certain amount of non-exempt assets. There are certain assets that qualify as exempt. We're not going to get into the specific AISH rules here today, but the maximum amount of non-exempt assets you can have and still be on AISH, to my understanding, is $100,000. And if you have more than $100,000, say in a checking account, you will lose your AISH supports. And that's not just losing the funds that the person would receive from AISH, it's also losing the access to the programs and supports that come along with being on AISH funding. So the way that the discretionary trust has been set up to operate, and the way that it's been approved by there's legislation that says this is okay. The amount in this discretionary trust, which is discretionary on the trustee as to when any amounts get released, works is that it doesn't vest in that person for whom they are the beneficiary of the trust. And the only money that gets counted against them for AISH or other governmental support purposes is the money that comes out of the trust for their benefit. So if there's payments being made to them or money they're getting, that counts for how much income they have for AISH, but not the whole amount of the money that they don't in fact have any access to. We also will sometimes use similar style trusts for an adult who has addiction issues so that they don't get all of their money at one time, which could cause a catastrophic event. Or sometimes we have situations where people just are not very good with money, and so then they also want to have a trust set up for that beneficiary just to sort of manage it and make sure they don't spend all of the money at one time. All right, so that moves us on to our general wills questions. So these are some commonly asked questions that I get about wills that I just thought I'd cover so that we've kind of got a bit of a starting place for everything. So, does marriage or divorce revoke a will? No, it doesn't formally revoke a will. Now, a divorce can revoke a gift under a will. Breaking up in an adult independent relationship agreement does not necessarily operate the same. But an actual divorce, like a signed divorce document, that can, in fact, revoke a gift. The law used to be that marriage revoked a will, unless that will was done in contemplation of that marriage, but that changed back in about 2010 with the new wills legislation, so that is not how the law works at all anymore. So one of the questions that often comes up is, well, what happens if my spouse predeceases me? Well, then they can't inherit and they can't be your personal representative. And that's one of the reasons why it's so important to put in alternates into your documents. If you're in a long-term relationship, you're probably one of the primary people you're going to be naming as an personal representative, as a beneficiary of your estate, is going to be your spouse or partner. But that person is of a similar age to you. You really need to make sure you've got some other people named in your assets. Named in your documents. Say, well, what happens if that person's not there? Who's in charge then? What happens if they're not there to inherit? What happens with your assets then? So you want to name at least a couple of alternatives for everything to say, okay, well, what are the backups if this person predeceases me, especially if it's a spouse or a partner? What if you no longer have an item that was given in your will? So let's say you said you were going to give your 2012 Toyota Corolla to your nephew, Roger, but you sold that car before your death. Well, unfortunately for Roger, that means there's no car for him to inherit. In legal terms, that gift would said to have a deemed, but basically it means is you can't give something you don't have. So that is unfortunate for Roger. Now, where we see this most often is gifts of personal property. But what I've often seen happen is the circumstances where it says, oh, I wanted to give, my paintings of this to my granddaughter, Elizabeth. Well, as it turns out, they no longer had those paintings at the date of their death because, you know what? They gave the paintings to Elizabeth while they were alive. So that happens a lot too. And then the gift still redeems, but the person still got the asset. So what if your person to whom you are giving a specific gift like that predeceases you? So in the will, you want to give your historical family chair to your son, Robert because he's your eldest son and that's how it's always happened. Well, if it's very important that it goes to Robert because it's the historical chair, um, but there's always a risk that Robert predeceases you, then you should name who the backup is to Robert, especially if it's very important that that asset falls within a specific family guideline or specific family line. So for things like heirloom, say, okay, well, if Robert's not there to inherit, then I want it to be his eldest child, who is Stanley or whomever. But that if those are important things that are important to you, that you've set that out to say, well, who's the backup if that person isn't there? Because otherwise, those assets just fall into the residue of the estate and get dealt with all of the other assets. All right, so finally, one of the questions we have is what happens if you change your mind about your will after you've drafted it? Sorry, I should clarify, after you've drafted and signed it. Well, so long as you still have capacity, you can make a new will. Now, that does require that if you've made a mutual will with your spouse, which is a very specific type of will, you would have done it at a law office, it's very specific. You can't exactly do that. But again, you should get proper legal advice in a situation like that. But typically the rules are you can always make a new will so long as you have capacity. You can also do a document which is called a codicil, which is sort of a shorter version, which is just a document that amends your will. So it says, well, this version of the will I did before stays the same, except I'm adding in this paragraph. I'm deleting this paragraph. I want to change who my executor is. And then you often do that in a document called a codicil. You say, I reviewed that will. Everything is great except for these couple of things. You can technically revoke your will by destroying your will. That one, so that's typically, so that under law is how that operates. The difficulty is sometimes it's hard to know whether someone destroyed a will or whether their will just went missing. So unless you destroyed it with witnesses and it's provable to say, well, I didn't want that will anymore, you tore it up and sent pictures to someone to say, I've destroyed that will, it's all wrong. Sometimes it's hard to know, well, did this will just accidentally get destroyed? And also, you have to have capacity to make that decision at the time that you revoke the will. Now, the other problem with that is that leaves you intestate. And it says, now I have no will. You are intestate. It's as though you never had a will. You can also sign a declaration of your intent to revoke your will. And that would, again, also revoke your existing will and leave you intestate. You'll see that if you ever sign a will at a law office, the very first thing the lawyers will do in the will is, okay, identify the person, I'm giving this will, and then I revoke all prior wills and codicils. That way we know that we're getting rid of anything that came before and we're starting clean and fresh for the estate. All right, so that is my presentation. Why don't we open the floor up to any questions, Matt?
Well, thank you very much, Anna May. Really appreciate the time and expertise that you've lended to us this afternoon. We did have a couple of questions come in while you were speaking, and I see a few others coming into the Q&A box. So we do have about 15 minutes or so for questions. So I'll get through as many as we can, depending on how many come in. And again, trying to keep things somewhat generic without getting too specific. So I'm going to go back. Someone had asked the first question not too far into the presentation about dying intestate. There's a two-part question. If a person dies intestate, will family members outside of the country, or can family members outside of the country make a claim? And then the other piece to this was if the person only has a spouse and no children in the country, can the spouse get all of the property, or do they need to go through some sort of specific process?
So there's no rules about people having to be in the country to be beneficiaries of the estate. I have an estate where someone died, they didn't have a spouse or partner, they didn't have any children. So now we're dealing with all of the siblings. And some of the siblings are just not in Canada. They still have a right to inherit. Where they wouldn't have the same rights would be to be an executor or an administrator, because under the rules of the Estate Administration Act, you're giving priority to the people who are in Alberta to be the people who manage the estate because they're here. But if you have potential beneficiaries who are in other countries, you would still have to give them notification. They are still beneficiaries regardless of whether or not they reside in Canada.
Okay. Perfect. Thank you. This question is around debts, and then specific gifts. What happens if after paying debts, there's not enough left to cover specific bequests?
So it depends a little bit on how the will is drafted, on what sorts of assets there are. There is a very specific term rules called the marshalling rules that say, okay, if we don't have enough money in the estate to pay all of the debts and all the specific gifts, you go through the specific, you want to get proper legal advice and say, okay, well, there's certain assets that get used to pay the gifts first, and then it goes down the line. But ultimately, you can end up in a situation where there's more debts than assets in the estate. Nobody gets anything in the will, and that's called an insolvent estate.
Okay, thank you. So here's a question that typically comes up at these sessions throughout the years, at least in my experience. What are your thoughts on a do-it-yourself will kit? Presumably that's better than nothing, correct? I'll turn it to you for that for that answer.
So do-it-your-will will kits, they can be better than nothing, but the problem is people, you have to recognize that, remember I talked before about how there's two different types of wills. There's a holograph will all in your own hand. There is a formal will. A do-it-yourself will kit has bits and pieces that are handwritten and bits and pieces that are printed. That means that whole will, that whole document is deemed to be a formal will if you comply with all of the rules for a formal will. I've had a couple of estates where someone tried to do a do-it-yourself will kit, didn't do it right, and then we ended up sort of scrounging around to say, well, is there enough in one of these handwritten sections that we can say, well, that's kind of um, a holographic will, enough that we can kind of put the pieces together and say we've got enough there to work with. And that needs to all be in one section, right? Like it's quite complicated. So look, I'm not wild about them. If you do them correctly, they can be useful. Unfortunately, I don't see people do them correctly that often. The other problem is that because you don't have someone who's familiar with will drafting writing all the information in, mistakes get made, things get misidentified, we forget to do the residue clause. And that opens the door to litigation, because if we've got something that's a little bit unclear and there's two people who are potentially interested who think that they should be entitled to one asset, well, and there's some disclarity, and you have a lawyer who can go to say, well, what did you mean? Was the
Right.
conversation you had with this person? That just leads down the road to litigation. So there's a lot of risk with using will kits. So I would strongly recommend that you get proper legal advice from a lawyer in your community. That's the best option for proceeding forward with a will.
I think that's also some of the advice that we as the Community Foundation offer quite often throughout these sessions. And that's the reason we have folks like you presenting at these sessions, is to make sure that people do have professional resources that they can turn to when drafting these very important items. I know in some other presentations, just from previous experience, I know other lawyers talk about their shoe collection that comes from disputing or litigating some of these wills that maybe go a little bit in a different direction. Back to the questions here, and since there was some talk about will kits and potentially holographic wills, here's a question. Is a will witnessed by only one person null and void?
The answer to that is it depends on what type of will it's meant to be. It depends a little bit on certain circumstances. I would say a will that is witnessed by only one person and it's a formal will is not presumptively valid.
Okay.
So again, that's where that falls back on getting proper legal advice. Make sure that the will that's being drafted is valid. It is properly drafted. You've met all of the legal requirements. There's nothing to say, well, why this will wouldn't be acceptable to the court.
Okay, thank you. I see some 3 or 4 questions that are around personal representatives, and I'll get into those right away. But since we're still talking about sort of specific will questions, I've got one here for a beneficiary. If you leave a beneficiary a gift, and in this case, an adult child, do they have all control, or can the beneficiary's spouse have an interest?
Well, I guess So typically, that mixes a little bit of estate law and family law. So when you're giving a gift in a will, if you name it to that particular person, you're giving it to that person. Now, when an asset is received by a beneficiary, it depends on what they do with that asset. So if they take that asset, it's initially what's called an exempt asset for the purposes of matrimonial property, the initial inheritance that they receive. However, if they take that asset and they put it in a joint account, joint with their spouse or partner, or they use it to pay off joint debt or to buy a house in both of their partners' names, they're giving away part of that asset to their spouse or partner. Spouse or partner doesn't presumptively have a right to half of that inheritance, but they would have a right to any increase in value on the inheritance, even if it's kept in a separate account. So the answer to that one is it's a little bit mixed, but it really depends on how you handle the inheritance once it's received.
Okay, thank you. There's a few questions here around personal representatives, so I'll get into this since it's a bit of a combination of both. Where did it go here? Is it correct that a spouse can be both an executor of an estate and the beneficiary?
Absolutely. It's quite common. You can have a personal representative or an executor of the estate who is also a beneficiary under the estate. It happens all the time. It's often a spouse, it's often an adult child. It's very common.
Okay. Here in Alberta, does your executor need to reside within the province?
So you don't absolutely have to have an executor who resides within the province. If you have an executor who resides elsewhere, then you run into one of two issues. Firstly, you run into the issue of bonding. So what that means is that an executor has a responsibility. If an executor is not resident in the province of Alberta, then they have to potentially provide a bond to the court. And the bond is basically 10% of the net value of the estate. And so let's say the estate is very simple. It's a house and a bank account. Well, a house in Edmonton, even if it's a tear down, let's say $300,000 plus a little money in the bank account, 10% of that is 30 grand. Most people don't have 30 grand to just pay into the court indefinitely. You can get that waived by having all of the other beneficiaries of the estate sign off on saying that they agree to waive the bond. And so that's one process, or we can hire a bonding company to pay the bond on behalf of the executor, but it does make it a bit more work. The other factor now is under the new grant application forms, it means we can't do a digital grant. We'd have to do the paper form grant, which isn't the end of the world, but it just does take a little bit more time because we're currying documents back and forth. One of the things that can make having an out-of-province executor harder is things like managing property. If the estate has a house in Edmonton and the executor's in Edmonton, they can check on the property, they can make sure it's being taken proper care of, all these sorts of things. If they don't live here, then they've got to find someone who can do that on their behalf or who can make sure the house gets cleaned out. So from a logistical issue, it's a lot easier to have an executor in Alberta. Is it an absolute requirement? No, but you just have to be prepared that there's some hurdles that are going to have to be dealt with.
Okay. Thank you. If the work of a personal representative, or let's say that the administration of the estate is a little too much for the personal representative to take on, would they be able to hire someone to help, like say a trust company or something like that?
They could hire a trust company. That is a situation where sometimes trust companies don't act as the executor, but they get hired on as the agent for the executor. That being said, you just have to realize that in that circumstance, what's being paid to the executor, to the trust company, is more than likely going to be considered a portion of the executor's compensation that executor would otherwise be entitled to.
Okay. And following up on that, is there a set amount to pay a personal representative?
There is not. In Alberta, we have some guidelines for what a personal representative can be paid. If you want to set it out, you can set out in your will specifically, I authorize, I want my executor to receive this much as compensation. You can do a flat fee, you can do a percentage on certain circumstances, you can do all sorts of things. But there isn't just a rule in Alberta. There are some guidelines that are heavily followed, but that's not a guarantee. And ultimately, if the testator or the person who wrote the will doesn't say in their will exactly how it's supposed to be dealt with, then it's up to the beneficiaries of the estate to approve the executor's compensation. And if they won't, then it's a matter for the courts. And then we go to a judge and see what the judge will approve.
Okay. And one more around trust companies. This person states that, of course, they can be appointed, but how does one determine whether a trust company is trustworthy? And in this case, I would think that it's likely the same that you would try and find your lawyer, just going through some of the conversation with different companies.
So the important thing to know about a trust company is that when you meet, so you talk to a lawyer, if you talk to your own banker, they can introduce you to the trust company that operates from that bank or operates in connection with that bank. You'll meet a trust officer. Now, that doesn't mean that if you die, that's the trust officer that's going to be managing your estate, because they have because that is just basically an employee of the trust company. They may or may not be there at the time. And, they may or may not have different duties at that time in the future too. Trust companies do have certain ethical obligations, like they're governed by legislation, they have responsibilities, they are held to a higher standard because they're expected to be, they do this all the time professionally, they're expecting to do this properly. And so, because they do this all the time, they have certain procedures, so that would be worthwhile to sit down with them and say, well, how do you guys handle this? What do you do in this circumstance, to sort of get an impression as to what the internal procedures are for dealing with the estate, what their timelines are, and if you're comfortable with that.
Okay, perfect. Thank you. There's a question here about learning resources to guide executors through their responsibilities. So I'm going to give ECF and Wills Week a little bit of a plug here. This year, we've combined sort of the wills and estates planning along with some estate administration resources that will come later in the week. So if you are interested in learning more about the responsibilities of a personal representative, I invite you to check out the remaining schedule of sessions that we are hosting, including an online session on Friday, to talk about the roles and responsibilities of the personal representative, so that maybe will provide you with a little bit of help if you have been appointed an executor or are looking to provide some of that information to somebody who has. There will be some specific resources that you can take from some of those sessions coming up. A couple remaining questions here, and just some sort of general ones. What is the best resource to offer seniors or family with low income in terms of a will, power of attorney, personal directive? Any examples or any advice for folks in those situations?
I think Sage has some materials that they can help for lower income seniors. They certainly have a wide variety of resources. Sometimes oh boy, I've forgotten what it's called. ECLC,
Edmonton
Community Legal
Legal,
Clinic.
yes, Edmonton Community Legal Center.
Legal Center. They will run, they do provide resources for low income individuals. They might have, I think they every once in a while have like some wills and enduring powers of attorney presentations, or they might have an evening where they work with that. So those might be some resources to look into.
And again, just to plug for ECF, we work very closely with ECLC. So if anybody was interested in connecting with that organization, we would be happy to make that introduction. So do let us know if there's some role we can play in that conversation. And the final question that we have here that we'll end on, because this is the last one in the Q&A, do you have any examples of clauses you should never use in your will, things you should avoid, or worst practices that you've seen that people should not participate in?
I mean, it's difficult because it's hard to make a blanket rule like that, because there's always circumstances where maybe I think it's overly complex. I think it's too onerous, but that's particularly what the person wanted, because a will at the end of the day is ultimately what the testator wants. And so sometimes it's a little more complicated. I think you really want to spend time thinking about how you can simplify things. We talked about household goods and personal effects, and I says, well, there's various ways you can have people come in and take assets from the house, but you really don't want to make that super complicated. I've seen ones where it's like, okay, and then we go this and we do that, and then okay, there's this. then we draw lots, and then we do this, and it can make it really, really complicated.
Mhm.
And that can just cause additional costs. You also want to think about, okay, well, I want to offer all these things, but what's the reasonability of this happening? If I want to offer, multiple options to purchase my property to every different family member, you have to just be realistic that that's going to cause a lot of extra time and expense for your estate because you can't deal with the property till all of these options to purchases have been dealt with. There can be good ways to deal with this, with some of these items. There's nothing that I would say is absolutely, oh, you never ever want to do that. I just think you really want to think about how much can you clarify things down and make it as neat and clean as possible. You know, what's the easiest way to refer to something? What's the easiest percentage or fraction to tell them so it's as clear as possible when it's read later on.
Excellent. Well, thank you. That clears the Q&A. So I'd like to say thank you to you, Anime, for your time and expertise, and always being so generous with helping us out with these presentations. I found I've been through this several times now, but always find something new and interesting to listen to. So I really appreciate your time and being part of Will's Week this week. Want to thank everybody for registering and tuning in to this session. And thanks to everybody for the great questions. I did put some resources in the chat. So if you'd like to see the remaining schedule for the week, please visit our website. That again is up over here behind my head. Or you can click the link that's in the chat. Did also put a direct link to Michelle's tax presentation that's happening tomorrow night. So feel free to use any of the resources that are available to you this week. We'd love to see you at as many sessions as possible. And do keep in mind that we will be posting these recordings on our website in the coming weeks after we wrap up. And finally, just before we say goodbye, I would like to remind you, if you do have a couple of extra minutes to stay on and answer the survey questions that will be popping up, please do so. Your feedback is super generous and very valuable to us to make sure that we are providing a worthwhile service moving forward. So other than that, I hope everybody enjoys the rest of the week. A happy early Thanksgiving to everybody tuning in. And please, I hope we do see you at future sessions. And before we wrap it up, Anime, any final thoughts from you?
No, just I hope everyone has a wonderful Thanksgiving week.
Awesome. Well, thank you, everybody. Really appreciate you being here. Enjoy the rest of your afternoon and take care.